March 1970, two attorneys file a lawsuit in U.S. federal court on behalf of Norma McCorvey, a Texas resident who wanted to terminate her pregnancy. The filing, Jane Roe versus Wade, argued that Texas's abortion statutes were unconstitutional and violated McCorvey's privacy under 5 constitutional amendments. In January 1973, a 7-2 Supreme Court decision in favor of Jane Roe rules that the Constitution protects the right to an abortion. The all-male justices found abortion was a fundamental right for a woman's life and future, writing that Texas had violated the rights of Jane Roe with an abortion ban that prevented her from having one. January 1974, on the first anniversary of Roe, anti-abortion rights activists gather in Washington, D.C. for the first March for Life rally to lobby Congress to change the law. September 1976, the Hyde Amendment, a restrictive measure prohibiting government funds to be spent on abortions, except in the case of rape, incest, or a threat to the life of the woman, is passed. June 1986, Missouri's governor signs into law a number of restrictions on abortion. Several of them were subject to court battles. 1988 and 1989, lawmakers in Pennsylvania amend the state's Abortion Control Act of 1982, adding 5 provisions, including informed consent before an abortion, a 24-hour waiting period, consent of one parent for a minor to have the procedure, and a husband notification requirement for married women. It was challenged by abortion clinics and physicians as unconstitutional. July 1989. The Supreme Court's ruling in Webster versus Reproductive Health Services upholds the law that the state of Missouri enacted, barring public employees and public facilities from being used to assist or perform abortions unless it's necessary to save the life of the woman. June 1992, Planned Parenthood of Southeastern Pennsylvania versus Casey. The Supreme Court's 5-4 decision upholds the provisions requiring informed consent before an abortion, a 24-hour waiting period before a procedure, and consent of one parent for a minor to obtain an abortion. The court did invalidate that husband notification requirement. November 2003, President George W. Bush signs into law the Partial Birth Abortion Ban Act, prohibiting doctors from performing late-term abortions. The law is challenged and blocked by federal courts in California, Nebraska, and New York. In April 2007, the Supreme Court upholds the federal ban on late-term abortions, ruling 5-4 in the Gonzalez versus Carhart case, finding that it was not unconstitutionally vague and did not impose an undue burden on the right to an abortion. July 2013, Texas lawmakers enact House Bill 2 with provisions requiring doctors performing abortions to have hospital admitting privileges no more than 30 miles from the abortion facility. And the facility must meet the minimum standards of an ambulatory surgical center under state law. Abortion providers in Texas challenge the requirements, arguing that they violate the 14th Amendment under Casey. This challenge ultimately ends up before the Supreme Court. June 2014. Louisiana's governor signs Act 620, a law nearly similar to Texas's admitting privileges law. Again, the law is challenged by abortion clinics and providers. June 2016. The Texas admitting privileges and surgical center requirements law is struck down by the Supreme Court in a 5-3 ruling. June 2020. The Supreme Court rules 5-4 in the June Medical Services versus Russo case to invalidate Louisiana's admitting privileges law, citing the court's 2016 Texas decision. May 2021, the High Court agreed to hear Dobbs versus Jackson Women's Health Organization case, the Mississippi law that bars abortions after 15 weeks of pregnancy. Later, Mississippi state officials would ask the Supreme Court to overturn Roe and Casey. September 2021, Texas enacts Senate Bill 8, or the Heartbeat Act, the first time a state successfully imposed a 6-week abortion ban since Roe v. Wade. The act also gave members of the public versus state officials the right to sue anyone who performs or helps facilitate an illegal abortion. the Department of Justice challenges SB 8, and in December, the Supreme Court ruled to keep Texas's ban on most abortions in place, limiting who can sue state officials. May 2, 2022, a 98-page draft opinion written by Justice Samuel Alito in the Mississippi abortion case is leaked. Justice Alito wrote in his draft that Roe was, quote, egregiously wrong from the start and must be overruled.